to this parliament, and the parliament then vets the candidate who has been recommended and the candidate who has been now approved by the president. So it's a really transparent, a very effective system for ensuring that the judge, one, has the confidence of the public because they were invited to give their comments, that it has the confidence of the Judicial Service Commission, it has the confidence of the Parliament. So it's a very transparent and a very good method, I would suggest, for appointment of judges.
Dr. Smit, would you like to add anything to this? Or...
Thank you. Just very briefly, it depends to some extent which level of court a judge is being appointed to. So in the lower courts, there is, I think, the strongest argument for a commission-like body, which in practice may have a very strong judicial component, but the highest courts are in their nature more constitutional, and that's where we see the widest variation around the world. There are so many different models, several of which have already been mentioned, and in the end, the tenure that the judges have as a result is the most important safeguard, because if they turn out to be independent-minded, they have that. So the only suggestion I would add to what has already been mentioned is quite a close parallel to India is what Pakistan has done, where they've also had judges' cases with the Supreme Court ruling on the need for the courts to be involved, but they've left at least some role for a parliamentary committee. So it's been constitutional amendments and basic structure, but the result has not ended up as much just in the hands of the judiciary. I just thought I would mention that because there is the advantage of getting, in effect, the buy-in of the other institutions, the branches of government who might find themselves ruled against by the top court.
Thank you. Lady Arden, would you like to say anything on this?
Thank you.
We can't hear you. No.
Lady Arden,
I'm so sorry to keep you all waiting. It's extremely interesting to hear the international experience. What is clear to me is that the needs of the judicial appointment system do depend on the culture, the circumstances of the country involved. But what I am certain of is that the independence of the judiciary is of paramount importance to the society and its citizens, and it should be bolstered by a strong judicial appointment system. Thank you.
Thank you. Mr. Datar?
Just a brief comment. I don't agree with Justice Albie Sachs on the legislature and judges not having a role at all. That would not suit India. In fact, in our analysis, we found that only 32 countries in the world, it's 16.8% of the UN countries, have a place where the legislature plays a prominent role. I think that the present system of giving judges a prominent role is good enough, is good. And what the feeling that the executive doesn't have a proper role also is not correct. Even in the Indian collegium system, where ultimately the final say is the judges, I'm sure many chief justices and judges who are here will bear me out, that the executive definitely has a role to play. Their recommendations, comments are definitely taken into account. And in fact, Chief Justice Kher has highlighted the role of the executive, an important role that the executive plays even in the present collegium system. So we have a system. There's no case where only judges appoint judges. It's also a participatory process, but the ultimate say is given to the judges. Thank you.
Thank you. Before I go to the question of removal, just one question. If we have some sort of an appointment commission or possibly appointment and removal commission, what could be the composition? How much role should lay persons have in it? I think Justice Albie Sachs, what would you
Yes,
say?
you know, we've had quite a lot of experience in that. I think we have 21 members of the Judicial Service Commission. It's presided over by the Chief Justice, which is very important for the judiciary. The Minister of Justice is represented, and the President of the country appoints 4 people as his nominees, experienced lawyers. So they're not lay people, but they're not judges. Then the legal profession chooses itself 2 from the solicitors and 2 from the advocates. We have one law teacher. I think that's something I would recommend as well. And then Parliament chooses people on a proportional representation basis. So it's roughly half the members of the Judicial Service Commission are legally from legal backgrounds, but from a variety of positions. Most of the members of Parliament, some might be lawyers, others not lawyers. And then the other half are legal people, but not from any particular block. And I might say that we find that the public hearings are enormously valuable for the public, not just to see the candidates, but to understand the qualities of a judge, the factors that are important, and the issues that are. It's very, very valuable in terms of public education. So they're not lay people chosen as lay people as such. They're lay people coming in their capacity as a law teacher or a member of Parliament, however that might be. And some of them are very, very smart and much more clever than the lawyers are when it comes to posing complicated questions.
Okay. As Lady Arden said, it also varies from country to country because the culture and traditions also vary, and what works in one country may not work in another. I don't know, Lady Arden, what do you feel about the suggestions of Justice Albie Sachs?
I was particularly interested in the point about composition of the Judicial Appointments Commission.
Right.
And one of the factors leading to the success of our Judicial Appointments Commission is the fact that the chair is a lay person, and there are lay people who are on the commission and take an active role in the process of choosing judges. They can bring their experiences of everyday life in fields which the judiciary do not have experience of, and they can also bring up-to-date knowledge of recruitment methods and what works and gets the best candidates. So in terms of composition, I underscore the point made by Justice Sachs by having lay people on the commission. We do not have a special seat for an academic, but very often there is an academic. There are certainly practitioners drawn from all levels of the profession, who therefore bring a wide experience of being in court. Thank you.
Thank you. Can we move to the subject of removal? Because basically the argument against power to remove judges is that it is a threat to independence of the judges. Because, for example, in the United States, they have some states which have some number of elected judges. And I remember a case where a judge gave a very correct verdict, but his term was about to finish and he was to be re-elected. His judgment was not liked by people and he was not elected again. So as soon as you have some sort of a system of removal, is there a danger that judicial independence will be compromised? And if we don't want independence to be compromised, what kind of a procedure can we have for removing unsuitable persons? I'm not talking about Kenya, where the constitution provided as an exceptional, bearing in mind the exceptional situation, that it was necessary. But in the normal course, can we have any kind of a provision for at least disciplinary action against unsuitable persons? Is it at all feasible, or is it better not to have it?
Sujata, that's the system. That's the system we have in Kenya.
Yes.
Anyone wanting to remove a judge has first got to complain to the Judicial Service Commission. Their disciplinary process would then go into the complaint and see whether there is justification. One, they ask the judge, of course, to respond. And if there is justification that there is a prima facie case sort of established before the Judicial Service Commission, then they recommend the appointment of a tribunal.
Yes.
And that tribunal is then appointed by the president. He selects the chair and he selects the composition of the particular members of that tribunal. That's the system that we apply in Kenya. And in fact, I have also been fortunate, or rather been honored, to chair this kind of a tribunal in respect of some of our very senior judges of the Supreme Court. And I think Smit, he knows it because I think he was with us at the time when I chaired one of these tribunals.
You see, we have something similar for the what we call the lower judiciary up to the level of the district judge, where the Chief Justice arranges for this disciplinary procedure and recommends removal or whatever other punishment, voluntary retirement, whatever it is. But for the higher judiciary, the only provision we have is impeachment. Justice Srikrishna, what do you feel about it?
I think the present impeachment process is all right, because what Mr. Sharad Rao is saying is that there is a tribunal which is appointed at the upon a complaint being made, and the tribunal goes into this charges against an erring judge and takes after complying with the principles of natural justice and makes a recommendation. Now, we have a similar system in the sense that when a sufficient number of MPs complain to the speaker, then the speaker appoints a committee of peers, judges of the rank of the Supreme Court judges or sitting chief justices, to go into a charge, and upon their verdict being against the judge, now the political process starts and becomes a little complicated. If it was simple, that upon a report made by this committee, the president would dismiss or ask the man to be removed because the president has the power, the matter would have been very simple. This political issue of voting upon that is the one that has created a complication.
But should there be such a process for removal?
It should be, because ultimately who is going to decide the fate of the judge? The peers who will find him guilty and the president who has appointed him. Absolutely no difficulty. Independence is preserved. Because obviously, I don't support a judge who has misconducted himself in whatever way that it is necessary to weed out such bad elements. But then, in the guise of weeding out bad elements, you should not subvert the independence of the judiciary. That is my only concern.
That is the crux of the problem.
Yes. Therefore, if you do not have this other political process of having to vote in the parliament and 2/3 number to be obtained and all that, it would have been a very simple issue. Just as it is the High Court, it would have been even in the Supreme Court.
Right. What do you think, Mr. Datar? Can't hear you.
Sorry, I muted myself to say so that others. Yes, I think that the present impeachment is not enough. We have to have some other alternative system, but it's going to be a complicated process, and I would say that it's better to start something on a trial basis, apply it in a few high courts and see how it works. First is, what are the grounds for removal? And if apart from removal, what are the other steps that can be taken?
Other steps, yes.
Yes. then who is the person who's going to take the step? Is it the Chief Justice or is it going to be the President? That's the next question. Secondly, what about the complainant? What is the nature of evidence you say? What is the kind of documents he has to file? All that has to be thought through very carefully, because we've got a system of number of people filing all sorts of complaints, and it becomes very, very difficult to manage. We've got a very, very bad tradition of people simply filing complaints against judges they don't like. So this alternative procedure can be perhaps structured with the help of retired Chief Justices of the High Courts and Supreme Court. A new set of rules can be formed and let it be tried for a few years, and then it can be implemented later. But definitely there is a need for some alternative system than just mere impeachment.
Ultimately, I am of the view that there should be an honor system. If my peers say that I am bad, I should just walk out, not contest it, then take the matter to Supreme Court and utter shamelessly say that I am not guilty. Finish. If my peers say that I am unfit to be a judge, I should just resign and go ahead. That should be the healthy convention.
Dr. Smit, you have studied this vetting process in different jurisdictions. What is your view about a safe method of removing judges without compromising independence?
Now, the vetting process was specific to a very specific form of systemic lack of independence of the judiciary.
Right.
And the challenge to the independence didn't come from the executive. It was the executive that had captured the judiciary. And so the people had no confidence in the judiciary. They went out into the streets and there was mayhem and people died. So that was very specific. It was one-off and it required institutional change, and it went with many other processes, a new constitutional text. It went with the Judicial Service Commission. It was part of a panoply. So generally, we don't like the idea of vetting, but in very special circumstances, it's the only way. In South Africa, the Judicial Service Commission has a very big role, but it's to investigate misconduct. And that's important. It's not either impeachment or nothing, because impeachment is very, very drastic. So we had a judge who was driving drunk. He smashed the car up. He told lies to the police. He went in for racial insults. The case dragged on and on and on for a long time. And by the time all the appeal processes had been through, I think he'd already retired. So he wasn't ordered to leave the bench. But we have another case that's pending. It's been going on for 12 years. The judge president of the Cape High Court, I'm one of the complainants. He went apparently to, when I was on leave, to some of my colleagues and did more than drop hints. He encouraged them to give a ruling in favor of Jacob Zuma. My colleagues were very upset. We laid a complaint with the Judicial Service Commission. He brought all sorts of procedures afterwards. The two colleagues whom he'd approached were rather hesitant about impeachment. And so at one stage, they didn't want to press ahead with it. Finally, they did. The Judicial Service Commission had a hearing. Tribunal of 3 recommended. The matter is going to go to Parliament now on the recommendation of the tribunal. So time is going on and on and on. It's complicated, but I would rather have a complicated procedure that can be abused than a simple procedure that could allow for pressure to be put on judges. Sometimes you've got to carry some bad eggs for the sake of preserving the general spirit of independence of the judiciary.
Thank you. Would Dr. Smit like to say anything?
Yes, and following immediately on what Justice Sachs said, that's one of the very difficult difficult balances that have to be struck in any functioning constitutional democracy. So, on the one hand, there are things that judges do that are so damaging to the justice system that judge does need to face proceedings. So I'm only aware of Brazil as a country where judges are effectively immune from any any removal. But on the other hand, any single action of removal affects the public's view, not just of that judge, but of the judiciary generally. So as Justice Srikrishna just mentioned, one of the pressure releases for all of this is if judges are more willing to resign. And the best mechanisms are mechanisms that end up not being used because judges who compromise themselves do that. In the study of the Commonwealth, we found that there were roughly equally distributed 3 types of removal. One is by a permanent disciplinary body. The other is by an ad hoc body, which is formed when serious allegations are made against a judge. And the third is the parliamentary method. So as Mr. Raz described in Kenya, the ad hoc model can work, but it's open to abuse on its own. Malaysia in the 1980s notoriously suffered in its judicial independence when the government formed tribunals to remove the Chief Justice and other judges. So it's important the initial stages of the process, who investigates, and at what point the public are told that there's something serious enough that a formal tribunal will be held. And that can perhaps appropriately be entrusted to the Permanent Judicial Service Commission. And then we're talking about a different body that doesn't just have appointments functions, and only some countries choose to have that umbrella. So that's one route. The other route is to have that judicial governance body as also the decision maker on discipline, which again is risky perhaps, but errs towards the side of judges being able to protect the institution against pressure. And finally, the parliamentary method. So there's a whole lot to say about this, some of it historical, but the model found in the Commonwealth is actually not impeachment. Impeachment still exists in the US, but the impeachment as accusation by the lower house and trial by the upper house is distinct from a process where the houses propose a judge's removal. And logically, really, that requires a prior disciplinary process, which almost all the Commonwealth countries that have parliamentary removal have established. So those processes then serve that crucial filtering function. And they can all work, but they're best used almost not at all and very sparingly.
Sujata, I have one comment to follow up on Doctor's observations. Now, we talk of an independent judicial commission, which will be entrusted with this job of guaranteeing the independence of the judges without compromising on merit. All right. Now, who is to guarantee the independence of the independent commission? Now, what is the mechanism? What if it is gamed? What if it is subjected to pressure? So we come back to the same question. If you can guarantee their independence, you can guarantee the independence of the judges also. It is like the policeman policing the policeman. This is exactly the problem that we have faced. And yes, therefore, it is always better to start at the level of the peers, put peer pressure on him and say, please go. And I mean, normally an honorable judge will say, we accuse ourselves. If a party appearing before me told me that I have no confidence in you, I'm not going to say I'm going to continue with the case. If I had any sense of honor left in me, I said, all right, I don't want to hear you. Let somebody else give you justice. Now, if that cannot be developed at the level of a superior court judge, I don't know how you're going to run the judiciary. Because if you have an independent commission, who is going to guarantee their independence? They will have to have a mechanism to guarantee, and this will become an infinite regress. So, I do agree with the doctor's concern, saying that there can be 3 types of cases. Well, let's take a simple case of behaving badly in public, maybe under drunken and being found in a disreputable place or something. Now, that is different from sleeping on the bench, which also is a serious misconduct according to me. Now, how do you deal with these? It depends on what the peer pressure is. Now, if you allow the independent commission to take a view, fine. If you guarantee me the independence of the independent commission, I have absolutely no difficulty. And if nothing works, parliamentary impeachment process should always work. What is the difficulty about parliamentary impeachment?
Let us, I think we can just wind up by saying something about service conditions when judges have an age of retirement. Should there be should there not be conditions which promote a judge's independence, so that he doesn't have to depend on the government or any other authority for his necessity after he retires? Because otherwise you have a spectacle of judges seeking different posts after they retire, which is not exactly conducive to independence. So I don't know if any of the judges here in their jurisdiction have had such a problem. Lady Arden, is there any such a situation there? I don't think so. Perhaps Mr. Datar can say something about the pension which the judges should have, or something like that.
Post-retirement pensions.
Yes, well, I don't know. I don't know what are the present system of pensionary benefits and medical relief. I'm told that the pension is quite good now, and the medical relief are given to judges for the rest of their life. So yes, yes.
The point is, it should be. It should
Yeah,
take
it should
care.
be. Yes. Especially now, yes. All the more reason. That's a very big incentive for good people to enter the judiciary. Yes.
Right. Okay. Anything else that anybody would like to add?
Could I just add that in the case of South Africa, we get a good pensions. We still regarded as judges, so we get a judge's salary, and our partner gets can be a beneficiary for his or her lifetime afterwards. And the idea is to attract people to give up lucrative practices or whatever else they might be doing to become judges, and B, to secure independence. Many judges now, former colleagues of mine, are sitting on commissions of inquiry. And that's, I think, a very honorable position to have. They have prestige. They do very, very good work.
I see. I don't know if we have the pleasure of having the Chief Justice of Kenya here.
I think she was, I think, heading some commission on judicial commission or something. That's what the registrar said.
Then I think, would anybody?
Can I just mention that Sharad and I vetted the Chief Justice when she was a High Court judge, and we both supported her nomination. And it's very encouraging to see that she's moved on to become the Chief Justice of Kenya.
I think she has joined in. Is that
I think she has joined us.
She has joined, yes. There she is. Madam Chief Justice.
We have been missing you.
Allow me, Lady Justice, to convey the apologies of the Honorable Chief Justice. Indeed, she was looking forward to joining the panel. She was really looking forward to joining the panel, but is chairing a session of the Judicial Service Commission that she is not able to delegate. So she has asked me to render her apologies and to assure that she will share her statement and continue engaging with other judges and with yourselves on this pertinent issue of independence of the judiciary. Please accept her apology and our utmost regards.
Thank you. Thank you. So now shall I call upon Mr. Nitin Thakkar, President of the Bombay Bar Association, to give a vote of thanks. But before that, I've asked Mr. Arvind Datar to make a summary of the conclusions which we have reached. I don't know if he is in a position to do it now or later.
I can do it later, but just to briefly mention that it was a wonderful session. We had inputs from various countries, various viewpoints. As Lady Arden mentioned, each country has its own problems and its own solutions. And I think if we can perhaps sum up the whole debate in one sentence, that the goal of every country is to get the best possible judges. That's the same goal all of us have. Only we have to take different roads to reach that goal. That's all. Thank you.
That's right.
Guarantee their judicial independence. Get the best judge and guarantee the judicial, his or her judicial independence. Both people that you have.
Mr. Nitin Thakkar, President of the Bar Association, would move a vote of thanks.
A very good evening to everyone who are present here. It's a great honor for me to propose this vote of thanks. On behalf of K.T. DESAI Memorial Committee and Bombay Bar Association, I would like to express my gratitude to all esteemed dignitaries from across continents for having participated in this roundtable. I thank you all for your presence and contribution to make this roundtable on judiciary, its independence and integrity a great success. The discussion from this roundtable will go a long way in understanding the essentials of having a judiciary which is independent and whose integrity is beyond doubt. This is hallmark of vibrant and mature democracy and needed for protection of fundamental rights, human rights, and rule of law. I extend my gratitude to each of our attendees, former and present judges of Supreme Court and High Court, senior advocates and other members of the bar for having taken out time from busy schedule to participate in the event from all over India and world. We had participants from Hong Kong, Kenya, South Africa, UK, amongst other countries. A special thanks to Mrs. Justice Sujata Manohar for providing immense support and inspiration to organize this roundtable successfully during pandemic. I must thank the organizing committee and particularly Dr. Birendra Saraf and Vishal Kanade for working hard for the past few days to make this roundtable successful. I will be failing in my duty if I do not thank BBS staff for managing the technical aspect of the roundtable. Thank you, everyone. Thank you very much.
Thank you. Thanks.
Thank you. Thank you.
Thank you.
Thank you, everybody.
Let us all hope that the judicial independence has come to stay and it will stay forever.
Yes.
Absolutely. I think we can't do without it.
Right. Thank you.
Thank you very much, all of you, for sparing time for this. Thank you very much. And I will circulate the conclusions to everybody. Thank you.
Thank you.
Goodbye.
Thank you to my co-hosts.
Thank you.
Goodbye. I've lost my video. Thank you.